I have a quick update on Lori Vallow's next trial. This is the conclusion of a document submitted by the prosecution. It is requested that this court determine whether the probative value of the defendant's prior conviction evidence outweighs the possibility of prejudice. In the present case, the admissibility of the prior conviction is well supported by the authorities cited above. It is established that in adjudicating a witness's credibility, the trier of fact should have the benefit of knowing the witness's criminal background. The facts of the present case indicate the credibility of the defendant is likely to be a paramount issue. Thus, if defendant intends to exercise her right to testify in support of her case, it would be unfair and misleading to the jury to allow defendant to appear as a pristine and innocent witness who lacks any, and we go on to the next page, previous criminal background. In such circumstances, defendant's prior convictions are very probative of credibility. For the foregoing reasons, the state requests this court allow the state to use the prior felony convictions as impeachment evidence should the defendant testify at trial. This ruling that the probative value of using that prior conviction for impeachment outweighs the danger of unfair prejudice and should be a specific on-the-record finding, State v. Poland, State v. Ransom. Listen, so what this is basically saying is that if Lori dares testify in her own defense, the state wants to be able to tell the jury about all of her convictions in Idaho. The JJ stuff, the Tylee stuff, all of that comes in. This is now filed, and they have some case law, so if the judge goes for it, that is now there. I feel like I should also mention a lot of people were unhappy with the juror statements after the previous trial, questioning whether they got information early about her prior convictions. Just so everyone is aware, there was also a document submitted by the judge making sure the defense is aware of that. So I don't think that's gone anywhere, but that is something that was submitted to the court. Just for the quick update, thanks for tuning in. It's going to be real short. I just wanted to give you this update because this is very interesting, because this probably, if it's approved, solidifies that we are not going to hear her testify in her own defense. I already didn't think we were going to hear her do it, but this would solidify it, because there's no way she's going to let that come in.